Good morning, everyone. Welcome to today's webinar put together by the CIAB Nigeria branch in collaboration with the Nigerian Bar Association. Today, we'll be discussing a topic: mining arbitration, trends, traps, practical tools for counsel and arbitrators. I have two stellar panelists today here, Dr. Victoria Nalule and Nakasamba Banda here. So I'll be introducing them, and as I do, they'll begin their presentations. Just to make everyone who is joining today's webinar, if you're new to the investment arbitration space, you might need to have a jargon book by your side to take note of terms that you are unfamiliar with. But I assure you that the panelists would try as much as possible to make this subject relatable to everyone who is attending. Now, Dr. Nalule is a dual qualified energy and infrastructure lawyer, qualified both in Scotland and Uganda. She's CEO of NEM Energy, an internationally recognized expert in energy, mining, and natural resources law. She holds a PhD in international energy law and policy from the Center for Energy, Petroleum, and Mineral Law and Policy, University of Dundee, UK, and serves as a natural resource law lecturer at the University of Bradford, UK. Dr. Nalule is a notary public, member of the Chartered Institute of Arbitrators, committee member of the CIAB Scottish branch, and International Chamber of Commerce YAF representative for Africa. With extensive experience advising governments, international organizations, and investors, Dr. Nalule provides strategic legal counsel and consultancy on energy transition, extractive governance, climate policy, and infrastructure development. She is a recognized arbitrator at the Energy Dispute Arbitration Center in Turkey and has engaged with leading institutions, including the African Union, African Development Bank, the International Energy Charter Secretariat, SADC Secretariat, EAC Secretariat, among others. A prolific author, Dr. Nalule has published 9 books and numerous articles on energy law, mining, renewable energy, and climate change. Her pioneering energy progression concept offers a tailored roadmap for developing countries balancing sustainable development and socio-economic realities. She's also the founder and executive director of the African Energy and Minerals Management Initiative, AEMI. Beyond consultancy and academia, Dr. Nalule actively shapes global energy discourse through conferences, media, and her podcast and YouTube channel. So after now, you might want to look for her YouTube channel and podcast to listen to. That's for our first speaker. So if you can give a bit of a round of applause in the chat box. Oh, great. Our second speaker, or our other speaker, Nakasamba, is a legal practitioner of 11 years. She's a commercial transactional lawyer with a holistic perspective and well-rounded view of commercial transactions, given her wealth of experience in matters relating to regulatory compliance, competition law, tax law, ESG, sustainable financing, employment law, alternative dispute resolution, and corporate insolvency. She advises both local and international clients on various requirements necessary for investing and doing business in Zambia. She has been lead advisor in some of Zambia's notable commercial transactions and mergers and acquisitions, including the acquisition of banks, amalgamation of entities, corporate restructuring of private and public listed entities, delisting of entities on the London Stock Exchange, negotiations of power supply agreements, concession agreements, and PPPs, project financing of various infrastructure and greenfield investment. Nakasamba has advised clients seeking to secure or restructure financing from international institutions. She's an advocate of the Supreme Court of Zambia and Commissioner of Oaths and Fellow of the CIR. She's currently serving as the chairperson of the Chartered Institute of Arbitrators, Zambian branch, and Secretary General of the Lusaka International Arbitration Center. She obtained her LLB qualification from the University of Zambia. She's an active member of the International Bar Association, International Competition Network, SADC Law. Welcome everyone to this webinar, and I'm assuring you you're going to have a wonderful time with the speakers as we open the floor. Now, in resuming today's conversation, we're going to start with Nakasamba, and part of what she'll be discussing are the trends in the mining sector. So my first question will be, what are some of the most significant changes driving disputes in the mining sector, and perhaps why? This question would go first to Nakasamba.
Hello, thank you very much, Daniel, for that introduction, and good morning. I believe it's still morning on the Western side. Thank you all for joining, and I'm really thrilled and honored to be part of this specialist webinar series, especially at a time when Africa is sort of in the spotlight when it comes to critical minerals. I think I do believe that this is a good starting point for this webinar to basically discuss the dynamics and contentious landscape of mining in Africa. We look at the strategic importance of each individual nation that mining has, and what some of the common causes of these disputes look like. I will also then give a few maybe examples and statistics within the continent in terms of what is happening with mining disputes. So I'll start by setting the stage with some context on Africa's mineral landscape. So as a continent, we generally hold at least 1/3, or let's say 33% of the world's total mineral reserves. And this portfolio is, of course, vast and varied. I did want to share some statistics from UNCTAD, but unfortunately it was a bit too late, but I'm happy to share them with you after this webinar in terms of some of the various mineral reserves that we have and the percentages and where they're found and what they're used for and what they're necessary in terms of critical minerals. But I think what is important is these minerals are essential for the global energy transition to cleaner, greener sources. And so strategically as Africa, we have become indispensable. We are an indispensable player in the global race for critical minerals. But more than that, you have, from a country-specific point of view, that the mining sector is usually just not another industry in that particular country. It generally usually forms the cornerstone of a particular nation's economy and accounts for a substantial portion of their revenue. I'll give you an example of my home country, Zambia, as a prime start. For us, it's copper. And mining essentially accounts for at least 70% of our export earnings. And in terms of government revenue, it accounts for about 28 to 30% of that government revenue. And it actually contributes 12% to our GDP. So when a single industry has this much strategic importance, it naturally leads to that significant state participation and the heightened risk of state intervention. So then the question is, where do the disputes then come from? And you find that the root causes of these disputes are generally intertwined. They create a complex environment for investors and all of that. And the first one would be the political and regulatory risk, right? Because as we've indicated, mining investments are politically and they're exposed to political and regulatory risks simply because they are capital intensive. They're usually undertaken over long project cycles. And so they find themselves spanning over several political administrations. So this long-term exposure makes them vulnerable to the shifts in government policies that then come up. Another underlying cause is what we call resource nationalism. And this is essentially a modern mining policy that is happening across all of Africa. There is this rise in what is known as resource nationalism. And this is the accession of a greater state control over natural resources and their profits. I find that at its core is often this attempt by governments to rectify what they see as historical imbalances in how mining contracts and concessions were initially awarded previously. And so you find this resource nationalism comes out through trends like, there's sudden unilateral changes to the mining laws, there's variation to the fiscal policies resulting in higher taxes, royalties, and custom duties. You then suddenly have new requirements for in-country processing or local content requirements. Even the issues of ESG are then sort of then coming up in terms of, there's new regulations for ESG and all of that. And parties are then forced to renegotiate existing agreements. Deriving from this, obviously, is what we all know and are privy to, which is expropriation. This is, I think, a primary political risk for many investors. Expropriation and nationalism, and I think this is how most of the states usually undertook their projects. If they were not happy with contracts, they'll just proceed by way of expropriation of the assets, directly or indirectly taking control of that asset or diminishing the project's value. But of course, now we're seeing it more in terms of indirect expropriation or creeping expropriation. Surprisingly, a modern driver of this risk, ironically, comes from stabilization clauses. And I know my colleague will talk a lot more about that. But just to highlight, I mean, stabilization clauses, which we used to put in mining agreements, were historically designed to protect investors from, say, for instance, changes in law or taxes. However, given the current resource nationalist context that I've just given, you find that states are now claiming that these stabilization clauses are actually infringing on their state sovereignty. And I will give an example of the Tanzania and the DRC in this regard. But just to give a few examples on the African continent to just show that these risks that I've talked about, and I'm summarizing them as resource nationalism, political and regulatory risks, and expropriation, that these are not just theoretical risks. We've actually seen them play out in time. You'll recall in Senegal 2016, their mining code suddenly provided that the state was to acquire at least 25% of shares in the mining companies. I mean, of course, if you're a mining company already in place and then suddenly there's a law that says you must divest of your 25%, that is bound to be a reason for a dispute, especially if it comes as a shock. We also had Uganda that in 2022, through its Mines and Minerals Act, gave the government a compulsory 15% free carried stake in all mining companies. I believe we also have Botswana that's currently going through the proposed 2024 amendments, which also seek to increase the local ownership in these projects. But generally, I find that Tanzania provides the most comprehensive example. You recall in 2017 that the country passed laws that essentially allowed for renegotiation of all resource contracts. They basically deemed everything unconscionable and prejudicial to the interests of people. And most of these laws were targeted at the stabilization contracts, which described them as creating a sort of separate legal regime for an investor. I think that's an example that I really would advise for if anybody is interested in understanding resource nationalism, is to look at the case of Tanzania. You also have the DRC. In its mining code in 2018, they significantly increased state control. They raised the royalties, key minerals like copper or gold, had an introduction of like a tax, 50% tax on profits. They doubled the state's free equity share to about 10% and basically reduced their contract stability period from 10 to 5 years. But also, I think when we talk about political risk, we must also recognize that even issues such as military coups, like for instance, the one that happened in Mali, in Burkina Faso, and in Niger, these were followed by assertive moves to gain more control over mineral resources. And these actions basically included, for instance, the revocation of mining licenses in Niger, in the Niger country, and the expropriation of gold mines in Burkina Faso. So when you look at, for instance, ICSID statistics, you will find that out of the 8 cases that relate to mining in the year 2024, you actually have 4 of them coming out of Niger because of these revocations of mining licenses and the military coup that occurred. So I think in a nutshell, I find that the mining sector right now on the continent is at this critical juncture. The vast mineral wealth is vital for the entire globe. And so the relationship between host states and foreign investors is being reshaped by a certain powerful wave of resource nationalism. And so it will really be important to see how we can balance this and create sustainable environments and investor-friendly regions. So, Daniel, I think for now, this is really the landscape of mining and some of the causes of the disputes currently pertaining on the continent. Thank you.
Thank you very much, Nakasamba. I would then move further on one of the points you made. You made mention of stabilization clauses and how that affects investments. From what you said, the understanding is that those clauses were created to protect investors, and the effect of it for state is how does that affect my ability to regulate within my state or say to make laws that affect say ESG or climate change or as I deem fit. Which then brings us to the next topic or the next question that will be answered by Dr. Nalule. Are stabilization clauses still relevant in the 21st century mining sector, particularly amidst evolving ESG and climate obligations? And how do they influence the trajectory of investor-state disputes?
All right, thank you very much, Daniel, and great presentation, Nakasamba. I really enjoyed it. So building on what my colleague has already said, first, the mining sector, we know it's a very essential sector, especially for the countries that have resources, because minerals are exhaustible, they are extractive. So there are countries that have these minerals and there are countries that don't possess the minerals. But for the countries that possess the minerals like gold, diamonds, and recently the critical minerals, which are very key for the energy transition, it becomes very essential for these countries to exploit and develop these minerals in a way that will benefit the country and also in a way that will benefit the citizens. So in the mining sector or even the extractive sector generally, we have some key stakeholders we really need to focus on. You have the host governments, you have the host communities or even the citizens, and then you have the investors. These three stakeholders have different priorities and they have different expectations from their minerals. The host government is looking to maximize profits, to get revenue from the resources. The host community and the citizens, like us, the citizens, we're looking forward to economic development, infrastructure developments, and also employment. And then the investors, they're non-charity organizations, so they want to maximize profits. Having understood the three basic stakeholders in the extractive industries and their expectations, now we move on to stabilization clauses. But before I even tackle the issue of stabilization clauses, we have to note the fact that our negotiations are very key in determining whether the government or the state will benefit from its minerals or not. Poorly negotiated agreements have been the cornerstone of a resource curse in many developing countries, especially in Africa. So mining agreements have various provisions, and each provision has to be well negotiated for the host government to benefit and for the citizens to benefit. But however, what we have seen historically and also in previous years is that we have had an imbalance in negotiations whereby the investors, who are in most cases international investors, because remember extractive industries or the mining sector, they're capital intensive ventures requiring large amounts of capital, which is often beyond the reach of any government. So you need international mining companies to come into your country. They always come with the expertise. They're well versed with the provisions, and they're also well versed with negotiating this kind of agreements. So some of the provisions that have been very problematic they're not the only provisions, but some of the provisions that have been very problematic are the stabilization clauses. But remember, also, we have to ask ourselves if other provisions in the mining agreements have also been negotiated in a fair way. Why do I say stabilization clauses have been very problematic? Because they basically serve the interests of the investor. So where exactly does the host state and host citizens lie in all this? And to answer the question briefly, in the 21st century, we shouldn't have stabilization clauses, and I'll come to that later. And the reason as to why we shouldn't have stabilization clauses, because they're mostly focused on serving the interest of the investor, minimizing the interest of the host state and also the interest of the host communities. So stabilization clauses can be provided for through the law. We have the legal stabilization clauses, but they can also be provided for through agreements like mining agreements. And we have two types of stabilization clauses. We have stabilization clauses of the legal nature, and these basically target the laws and the contracts in that the legal terms of the contract and also the laws in the country that have been in existence at the time of signing the mining agreement should remain the same during the life cycle of the agreement or during the life cycle of the project. This might not be problematic if these mining projects, were only for 2 years. But remember, extractive projects or even mining projects, they are long-term ventures, often taking like 10 or even 15 years. So in 15 years, if you have frozen the government's ability to change laws that are going to negatively have an impact on the investor, where does the aspect of sovereignty come from? No parliament and no country should be held a prisoner when it comes to their ability to change their laws, because societies are always evolving. The economics and political structure of the countries are always evolving, implying that the laws also have to evolve. But with the legal stabilization clauses, let me give an example. If mining company A came to Nigeria and entered into an agreement with your government, then they have a legal stabilization clause that can also be like a freezing clause. That clause will be to the effect that during the 15 years when mining company A is going to be operating in Nigeria, the government shouldn't change laws or introduce laws that will have an economic impact to the company's ability to make profits. But remember, this kind of requirements are not present in developed countries. No developed country has stabilization clauses. Stabilization clauses are mostly in developing countries, Ghana, Uganda, Mozambique, Angola, and Nigeria. But developed countries that also have resources like Norway, the UK, USA, Canada, because these are also mineral-rich countries, they don't offer stabilization clauses. So the fact that these clauses are only applied in a few countries, it's also problematic. And most people would say, okay, this is the history of stabilization clauses because they date back to the 1930s. And the history or the essence of stabilization clauses is to provide that stability for investors, especially because they believe developing countries are always unstable politically, and also they're always unstable when it comes to changing. They often change their legal frameworks. But the UK has changed their fiscal regime for quite some time. So their fiscal stability is not that good. But why don't companies that operate in the UK ask the government to give them their stabilization clauses? And when it comes to political insecurity, yes, that was the thing of the 1990s, but most African countries are now politically stable. So why are you still offering the stabilization clauses if most African countries are now politically stable? So we need to really start to ask these questions. What was the essence of stabilization clauses? Now, do we still need them? Because right now, they're not relevant. Right now, they are only escalating disputes between investors and the host state. And the basis for the disputes is because the host, the investor, is more focused on generating revenue. They're not charity organizations. They don't care if your country is only getting 10% of the revenues from the resources and they take 90%. For them, they're more interested in getting the revenue. The host state, they're more interested in making profits. The host state is also fighting to get the revenues. The citizens are fighting to get developmental infrastructure and to ensure that their resources turn into a blessing. But we are faced with a situation where when we talk about a resource curse is where like countries that have minerals are the least developed. African countries are always like the perfect example of a resource curse. And obviously there are various issues or reasons that can be given, including corruption, poor governance, and so on and so forth. But as lawyers, we also have to be very realistic and say, even the contracts that we negotiate are bad. The contracts that we negotiate, the mining contracts and agreements that we negotiate, they are not favorable for the people. We are selling our resources for pennies. And that's why we are experiencing this resource curse. That's why we are finding that many resource-rich countries are not economically developed. And one of the reasons for that are these stabilization clauses that we often offer. So you have the stabilization clauses of the legal nature, like I mentioned, but also you have the economic equilibrium clauses. With the economic equilibrium clauses, they freeze the government's ability to increase royalties or even change taxation laws. So after 15 years or after 10 years, do you expect the company that was offering like 5% royalties to be offering the same? After those years, things have evolved. So the government should be in a position to revise the royalties, to revise the taxation rules to ensure that they can also benefit from their resources. But these stabilization clauses, that is basically what they do. Obviously, they can be rephrased, they can be renegotiated, but the question is, do we still need them in the 21st century? No, we don't need them because they have been the main driver of various disputes. And we are, yes, please.
Not to cut you, but you make a very very significant and interesting point. But from the standpoint of an investor,
Yeah.
I'm wondering if I'm an investor and I know that there has been issues in Africa and that were maybe politically or issues that affects governments, different government regimes. Seeing how Africa works, a government comes into power, one government comes into power and starts its own affairs, not continuing from where the other governments, picked up from. So in terms of policy changes, my point then is, apart from having a stabilization clause for me as an investor, what other way can the balance be achieved between investment or investor protection with state sovereignty and reduce the risk of mining related disputes?
All right. Yeah, thank you very much, Daniel. That's a very significant and very important question because yes, as an investor, you have to be able to ensure that your investments are protected. So besides stabilization clauses, because I will stand by what I said, they're not necessary, we don't need them. So the question is, what are the alternatives for stabilization clauses? We already have the alternatives in our countries. The first thing are the national investment laws. National investment laws in different countries, all countries, African countries, they have investment laws. These laws protect investments, different types of investments, not just mining investments. Agriculture, investments in the agriculture sector, investments in the construction industry, investments in the healthcare. So all those mining codes, investment codes, investment codes, national investment codes, offer the same protection. That protection could even include for investors to be protected against nationalization and expropriation. And also that is a protection that is provided for in different constitutions. And also the same protection is provided for in multilateral investment treaties, in that if the investor's property or even assets are nationalized, they are entitled to compensation. So the first thing that all countries have are the national investment laws. And I'll give an example. Rwanda's Investment Code of 2021 clearly outlines investor rights, including repatriation of profits and protection from nationalization and expropriation without compensation. Botswana also has investment laws, national investment laws. So all the protections that we think in our mind that they're only provided for by stabilization clauses, all those same issues are covered in the national investment laws, which all countries have. So besides the national investment laws, we also have bilateral countries, especially developing countries, have entered into BITs with different countries. And most of the mining companies are coming from these developed countries. And you will find that, for instance, Mozambique has a BIT with the UK. Germany has a BIT with Ghana, which dates back from the 1998. And different developing countries have BITs. So these BITs also offer the same protection as the stabilization clauses, but only that they can apply to all investments, not only mining or extractives. Then besides the BITs, we have the multilateral investment treaties. Most countries were party to the Energy Charter Treaty, and the Energy Charter Treaty, the provisions of the treaty offer various protection to investors. Besides that, we have regional protocols that also protect investments. I'll move from the mining sector and go a little bit to the energy sector. In Nigeria or in West Africa, you have the ECOWAS protocol of 2003. The kind of protection that protocol offers to investors is even better than what the stabilization clause will offer. In Southern Africa, they have the SADC protocol that also offers the same protection. Now, at a continental level, we have the Africa Continental Free Trade Area. So you realize that we have various mechanisms of protecting investments. And these mechanisms are capable of protecting mining investments. And as such, you don't need the government to become a prisoner, to freeze their ability to change laws, just because in our mind we think, oh, if we don't offer stabilization clauses, investors will not come. They will come. If you all make a decision as a continent, they will come. So Daniel, that's it. Thank you.
Thank you so much, Dr. Nalule. I would stretch the conversation because I don't know if Samba holds the same opinion about stabilization clauses, because Dr. Nalule holds strongly that they are no longer necessary, that we shouldn't have stabilization clauses. And my question is, seeing that we are an investor-driven continent mostly, wouldn't that be a discouragement for investors? That's one. Two, the reason why most investors want a stabilization clause is because I want certainty in my investment. I want to know that if I put my money in, or I get into the ground to mine, or I'm carrying out an investment in your state, I am protected. I can calculate my income. I can calculate the risk. That's why I'm having a stabilization clause. I get you, and I hear you that, that if we put our foot down as a continent, all 54 of us, and say, no, we are not moving and we won't have this clause, investors would listen. But what would be the impact before they begin to listen? And that's what I'm thinking. So I want to just ask Nakasamba, do you hold the same opinion that stabilization clauses are no longer necessary?
Yes, of course. I mean, the argument has been put forward by Doc. It's very difficult to argue against that. But yes, I think I really do. I do agree that stabilization clauses are not necessary per se a requirement to provide that investor climate. I think the conversation should be about, as Doc has indicated, we have laws that provide for investor protection. What are we doing in terms of good governance to ensure that we actually provide this positive investment climate? And if we are actually going to change laws, which is what we're trying to say, you should not prohibit that. How are we going about it? Is there consultation before you actually just randomly impose a new tax law or whatever it is you want to change? If you have stakeholder engagement and everyone is moving at the same pace, ultimately you find that that's actually what avoids the disputes. Because as we've indicated, resource nationalization and everything that African governments are trying to do is because they believed that you gave them a raw deal. So the only way is to simply say, you know what, I'll just breach. Let's figure out how we get out of this really bad contract. So if the alternative is we move together, we all have the same goal, which is development of our continent, then I think stabilization clauses have no place in the 21st century as well.
Thank you. Then I would move to my next question, which is more often we are seeing allegations of corruption. They seem to be very pervasive, in mining arbitration. How should tribunals handle evidence of corruption or illegality in arbitration proceedings, particularly where it implicates the investor or the state actor?
Thanks, Daniel. That's well, there are hands here. I don't know if you want to proceed with it.
Okay, I would just say to the hands that are up, kindly hold your questions, and we would move to the question and answer session very, very, very soon. So we'll take questions. Yes.
Okay, so I'll just quickly summarize this, right? I mean, I think corruption is one of those escalating challenges within the mining sector specifically, because you find most of the disputes and the arbitrations always involve these allegations of corruption. But this is, of course, not just prevalent in Africa. I think that's really critical to remember. It's not just in Africa where you have corruption, it's everywhere. It's not just in mining, it's really just international commerce. It's like a cancer. It distorts competition, it erodes the very fabric of society. But there's one issue that I find really interesting about corruption in Africa, and that's the relationship between corruption and FDI. That's foreign direct investment, which tends to create this nuanced and sometimes contradictory picture. I've actually come across economic perspectives that suggest that it has a helping hand hypothesis. So basically they say, paradoxically, corruption facilitates FDI. Please don't kill me. It is not me. It is the economist perspectives. It facilitates FDI in environments that are actually characterized by weak regulatory frameworks. So basically they help grease the wheels of commerce. I'm pretty sure you've all been party to, getting things done in the corridors of bureaucracy where you need to somehow pay someone off to get things done. And I think this is where this hypothesis comes from. But then conversely, on the other side, they support the grabbing hand, which is the Sons in Wheel, where they say that, basically corruption impedes FDI. It increases uncertainty and the transaction costs and all of that. But regardless of this pervasive nature of corruption, I think ultimately it's more pronounced in investor-state dispute settlements, because that allegation of misconduct, it actually has the ability to stain the entire investment, the entire mining project, and if a dispute arises, it actually influences the trajectory of the outcome. So I think in summary, what I'll try to do is just try and distinguish, I think as a starting point, what the effect of a corruption allegation would be if it's an investor-state dispute versus what it would, if it falls under ISDS, versus what it would be if it's under an international commercial agreement. I'll then try and look at some of those inherent conflicts that now arbitrators are faced because of the allegations of corruption, in terms of their duties and the discretions and dilemmas based on how we understand arbitration generally. And then I think when it comes to some of the recommendation or strategic reforms, I think this is something that I would like to hear from the attendants in terms of how they think we can mitigate some of these risks. So obviously, as a starting point, as I said, I'll distinguish the effect of corruption on an ISDS versus an international commercial arbitration. And this distinction is primarily derives from the fundamental difference in the jurisdiction and underlying arbitration principles, right? If you look at ISDS, the arbitration agreement or the offer to arbitrate is contained in the bilateral treaty, right? So basically the host state is giving a standing offer to arbitrate. It's contained in the treaty. So the arbitration agreement hasn't crystallized at the point that you're actually entering into an investment. So if a claim then arises that there was corruption, essentially what someone would be saying is, and maybe, I mean, of course, I'll talk about how the treaty itself is what provides for who's actually protected under that treaty. So it will be a protected investment. So if then a dispute arises and there's allegations that there was corruption, essentially what you're saying is there is no protected investment here. And so the arbitration, the offer itself cannot then be accepted. You're not protected there. So ideally, this form of interpretation would then affect how you determine the jurisdiction of the arbitrator in an ISDS case. With an international commercial arbitration, obviously this would arise because an investor comes in and a specific contract is signed. So you're not relying on the treaty to actually, the treaty or the multilateral treaty to actually determine the arbitration agreement. You're relying on an actual signed agreement that provides for the arbitration agreement within that contract. And so obviously the underlying contract, we all know the principle of separability, right? So the arbitration agreement is distinct from the main contract, such that even if an allegation of corruption is then made, it doesn't invalidate the jurisdiction of the tribunal. Essentially, it's an admissibility of claim issue. It's an argument that you raise during the argument as to whether or not this contract is enforceable. So that distinction is really important and has been the subject of various cases. You look at the Metaltech versus the Republic of Uzbekistan. This is an ICSID case. For that one, obviously, it was they actually provided that it fell outside the bilateral investment treaty because there was allegations of corruption. And then obviously in comparison, you've got the World Duty Free Company versus Kenya, the Republic of Kenya case, where the president basically was provided with a payment. In that one, the tribunal concluded that the claimant had no right to pursue the claims stemming from the corruption, but the arbitrator actually had jurisdiction to determine the matter. So then moving on then to the next issue that I said in terms of what then the duties and the dilemmas and the discretions that come about because of these allegations of corruption. I'll summarize and I'll give 4 examples, right? The first one is essentially proving the corruption in an arbitration. I think by its very nature, we all know corruption is clandestine. It's not like anyone will leave an actual note saying, I gave you this money. So it's very difficult to prove corruption in any particular case. So then what then happens when an arbitrator is then faced with these allegations of corruption? Initially, arbitrators always said, I have no business with that. It is not part of my jurisdiction. They always looked away. But increasingly now, arbitrators have found themselves to actually be the protectors of the legal systems, and they're more and more they're determining these matters. But you find that you create these dilemmas because it's going against the basic principles as we know them. So for instance, if you think of burden of proof, right? The burden of proof is on the party that alleges. But if a corruption claim is then made, all you have as a person is the red flags that you can point to. They're not necessarily foolproof that there was a bribe that was paid. So now what an arbitrator has to look at if they're faced with these red flags is the possibility of shifting the burden to the party against whom the red flags have been brought against. That's because that's the only way that you actually come up with a fair determination. Again, obviously against the principles as we know them. You then also find the fact that he has to rely on circumstantial evidence. When we talk about standard of proof, corruption has always been, it's one of those, it's preponderance of evidence, balance of probability. It's always that higher threshold when you talk about corruption. But now an arbitrator is having to rely on circumstantial evidence. So the critical inquiry then becomes, is this circumstantial evidence compelling? Does it provide a consistent body of evidence that is sufficient to actually establish corruption? So ultimately, all of this is a tricky situation for an arbitrator. And of course, you will, after your arbitration is determined, you have an award. Believe me, there'll always be something in the media as to what you didn't do right, what you did right, what you should have done. I'm sure we've all had those conversations. But I think what I have seen is, what I find useful is the recognition of the red flags. And a useful tool is the ICC red flags document. This basically provides how an arbitrator should go about a systematic methodology for actually evaluating these indicators. And the indicators are basically divided into general red flags, where these are like the immutable contextual characteristics, such as the country's reputation, on the corruption perception index. You have, the industry historical track record, and, we're talking about mining there. So the track record it's bad. It's always prone with corruption allegations and actual corruption itself. You look at the chaotic political environment. Those are the specific red flags. And then you get into the specific red flags, which then stem from the actual characteristic of the transaction. What is the background of this party? Were there these unusually high commissions? Were there overcompensation of third-party agents? Things like that. Lack of process in terms of the procurement processes. Was there due diligence undertaken? All of these will sort of help an arbitrator determine that there are red flags here and there could be arbitration allegations. That's it on the proving of the corruption. The second issue is the investigative powers of arbitral tribunals. And I think traditionally we all know that in international arbitration, it operates with an adversarial system. So basically the party that is proving, they bear the primary responsibility for presenting their case. But now with the rise in corruption, you have a model where the adjudicator now typically focuses on not only issues of law and procedure, they themselves have to initiate inquiries directly questioning these witnesses. But the question then becomes, how far can you go? What is really your role? And because unlike domestic courts, a tribunal doesn't possess the investigatory powers. They lack the capacity to compel production of relevant information. So really, where do we draw the line in terms of what the arbitrator's duty will be? And the third issue that I note is the asymmetry problem, which for me, I find that the whole concept of corruption creates a very perverse incentive for states to engage in corruption, because ultimately they then come back and use this corruption as a shield against the investor. So essentially, the application of the clean hands doctrine and all of that, it's essentially an upholding policy and the eventual outcome, but then we're not holding states accountable for actually being involved in that corrupt act, because it's their agents that commit these corrupt actions. I found two cases that were very interesting, and that is the Metal and Incensa case. This is it was against the El Salvador Republic, and then you also have the Spentex Netherlands versus the Republic of Uzbekistan. In the first case, the Metal case, the tribunal acknowledged the state's participation, and in doing so, all they did was basically allocate the costs. So basically trying to reflect an effort to balance the equities. In Spentex, however, the respondent was actually requested to contribute to the UN Anti-Corruption Initiative, and it was a huge payout. It must have been about $8 million that the state had to pay. Of course, this is a controversial approach, but you can see it's an attempt to address some of these perceived unfairnesses that are the outcome of this sort of complicit state in this action. And then other challenges that you face as well is, okay, you've got allegations that are being made before the tribunal, but you've got domestic proceedings, criminal domestic proceedings. Which one will take precedent? The lack of investigations sometimes is actually, it deprives the tribunal of potentially relevant evidence. But remember, ultimately, a tribunal would not be bound by the outcome of these domestic investigations. So the question then is, how does the tribunal then
Thank you very much. Over here in Nigeria, once you say corruption in arbitration, our minds all go to a case that you already know. We all think of the PNID case. I know
Yes.
everyone says we should stop talking about the case, but immediately you say corruption, I'm sure everyone in the room just started thinking, PNID.
No.
And yeah, and for some reason I couldn't get past what you said that there's a school of thought that corruption actually encourages FDI. I am sure that statement or that school of thought cannot be from the state where the corruption is going on, because the state in itself would not be benefiting from it. It would be individuals and people who will benefit, and not the states as a whole that will be benefiting from that corruption. Anyways, thank you so much for that well delivered answer to the question earlier asked. I'll be asking my final question before we move to the audience. So if you have questions, please begin to drop your questions now, because there are so many messages in the comment section. So please, you can start dropping your questions now, and I'll go through them once the last question is answered. This is to Dr. Malule. How can extractive and mining contracts be effectively renegotiated to align with global climate obligations while minimizing the risk of investor-state disputes in Africa? I'm sure it's obvious why this question goes to you.
All right. Thank you very much for that. So some agreements would have provisions for renegotiating the contract in case of any advanced changes, but that will only come in if the mining agreement itself provides for that provision. It has that provision in it. So once the provision for renegotiation is already provided for in the agreement, it becomes easy, because in cases of any economic changes, legal changes, the two parties, that is the investor and the host state, can sit on the table and decide how to renegotiate, what new terms they can introduce, what other terms can be changed, as in on a case-by-case basis, but also in a way that ensures a level playing field, in that the investor will be benefiting and also the host state will be benefiting. So that's one major way where the renegotiation clause is already provided for in the agreement. Now, let me go on this last part of how to negotiate the mining agreements to align with the ESGs, or climate change obligations. Let me start by saying that African countries, we don't need to be followers, because the current thing right now is the global climate change, the energy transition, and we are all moving towards that direction. The ESGs, all these things are very important, but we have environmental laws that also address the same environmental concerns. All countries, including Nigeria, you have environmental acts, not so? And different countries like Uganda, Kenya, they have environmental laws. Those environmental laws are effective to tackle the ESG aspects, or even climate change obligations. The other thing that we have in most mining agreements and petroleum agreements, they also have environmental provisions that are to the effect that the investor has to carry out their activities in a way that is environmentally friendly. But the challenge that we often face in developing countries is the issue of implementation, because all the laws are there, the laws that are against oil spills, gas flaring, like the message I've seen here of what was happening in the Ongoni land in Nigeria, in the Niger Delta, all the laws are there to ensure that we protect the environment, but we never implement. And then the institutions that are supposed to be implementing are also weak. And then the issue of corruption that Nakasamba has talked about also plays a big role. So when it comes to renegotiating, we don't need to renegotiate mining agreements to align with climate change goals or ESGs, because in most cases, we already have the necessary legal frameworks that, if they are well implemented, will be in a position to protect the environment and also to ensure that people's rights are protected. Now, let me just tackle on this last bit of the climate change and the ESGs. It's a global topic now, and it's attracting a lot of investments. But let's be honest, for African countries, especially, and now that we're talking about the mining sector, we know of critical minerals that are very essential for the energy transition. And our focus should not be on aligning these mining agreements with climate goals, because we are not even big emitters to start with. We're not responsible for climate change, but rather how we can negotiate these contracts in a way that will position us to be the main global players when it comes to supplying these critical minerals that are needed for the energy transition. So we are always being swayed with these new terms, the energy transitions, climate change, and everything. And then at the back of our mind, we're like, oh, we need solutions. Yet in actual sense, we already have the solutions. We already have the environmental laws. We have environmental provisions in our mining agreements and even petroleum agreements. So we do not necessarily need to renegotiate mining agreements to align with climate change goals, but rather we need to renegotiate mining agreements to ensure that we are top players in the supply of critical minerals. At whatever cost that might be, we need to be top players in a way that we'll be able to benefit, the countries will be able to benefit, the citizens will be able to benefit, and also that we can become global leaders. So, Daniel, that's it.
Yes.
I think.
Thank you. Thank you very much. I think you started off with a point that I think will lead us to the first question here, which is that we already have these laws, and our problem or the issue then be with implementation. The first question is by Bello Tuko, and he says, I concur with Dr. Victoria and Mrs. Nakasamba that we have adequate legal framework that will offer maximum protection to local and foreign investors. But don't you think that the stabilization clause may be relevant, especially in jurisdictions where enforcement or implementation mechanism of these legal framework are very weak due to corrupt practices, nepotism, and so on? So it takes us back to the question. I knew your position on the stabilization clause was going to, have varying views. So that's the first question. I think we should go to, well, any of the speakers can take the question.
Yes. Well, I mean, look, I mean, we have addressed the issue. And if the issue is that you're talking about jurisdictions that do not have, oh my word, sorry, I'm at home.
Right.
Yeah. So if you're talking about, a jurisdiction and you're like, okay, stabilization clauses are the only protection for you. I mean, how are you even going to enforce those same stabilization clauses in a jurisdiction that you don't trust? Because even the legal system there will not allow you to enforce them. So it still goes back to the same issue. Ultimately, if there's other ways of actually resolving the issue holistically, it should be done to benefit both parties.
Do you share that same opinion, Dr. Nalule, because you started the argument on whether it was needed or not?
Yeah, I believe that whether it's an issue of stabilization clauses or not, mining investors always insert an arbitration clause in the agreement. So whatever issues they have, it will not be a matter of how it's going to be handled at the national level. They would rather go to international arbitration. So if you are saying that stabilization clauses are needed because some jurisdictions have legal weak legal frameworks. Ish. You mean like if an investor has other issues, they're going to bring it through the national laws or the national courts? No, because most mining agreements have arbitration clauses. Like I said, we don't need stabilization clauses. We don't need to make excuses, because whatever reason you can even think of, you already have a solution. Thank you.
Thank you.
And
Do you
also
see the
just to add,
yes,
I mean,
please
just
go
to add, I don't think there's any investment that's risk-free. It's always important to recognize that. So if you're going to be investing in any jurisdiction, the first thing you do is a full-on due diligence. What is this legal framework, and are you willing to invest there? So if we internally work on our legal systems to ensure that we provide good investment climates, then as an investor, you should be willing to accept that this is what's being offered. There is a slight risk of changes in law, but that is a slight risk, and that risk will be there anywhere else in the world.
The next question is from Chukudi Oswago. It says, do you see the possibility of the creation of a regional/domestic regulatory framework for seabed mining? So regional framework, I think is in the comment section. The question is, I hope we've seen it, yes.
Doc,
Well, I think, should I pick someone, or we just, okay, maybe Doc pick the question.
All right. Yes, I think we already have initiatives at a regional level, African level, to address the mining sector generally, not really specifically deep sea mining, but it's also mining. We have the Africa Minerals Development Center, that is the AMDC, and they have formulated various laws and strategies, not really laws, but rather strategies that are intended to ensure that African countries are in a better position to benefit from their mining sector. So the starting point would be to utilize the already available regional frameworks, mining regional frameworks that we have. And most of these are under the auspices of the African Union. And I know that AMDC, that is the Africa Minerals Development Center, plays a big role. We also have the African Mining Vision. So the fact that deep sea mining is part of mining, we can basically rely on the available frameworks that we have at a regional level. But where there are some unique aspects that have to be addressed, then we can have different strategies to address that. So to answer the question, I believe we already have regional frameworks, mining frameworks in place that we can rely on to also develop the deep sea mining.
Okay. I'm scrolling down to see if there are more questions. Okay. There's a question here from Theophilus. I don't understand the question. It says, how do you assess the new uncitral provision? Okay, the new uncitral provisions that investor state arbitration should avoid confidentiality requirements of normal arbitration process. I don't think I get the question. If you are the one who asked that question, you might want to make direct reference to the provision you're referring to, except any of the speakers gets the question clearly. I don't think that question is clear enough.
I don't understand the question.
Sorry, I'm on mute. Yes, could you maybe repeat the question?
I will have to scroll up there. There are a number of messages and moved on from there. Coming.
Okay,
Just a
no
minute.
problem.
Okay, I will ask another question while I find the other question. This is from Emmanuel Ibekwe. He says, it's not safe for investors. Is this a question? It's not safe for investors to opt for clauses that require renegotiation if circumstances change significantly. Okay, that's not a question. Just a minute, just a minute. There are a number of messages that are not questions here. Bear in mind that jurisdiction of an arbitral tribunal is ordinarily civil and is particularly circumscribed by law and the agreement of the parties. How can the issue of corruption, which is criminal in nature, be validly raised before an arbitral tribunal? This is from Harrison Ugwala, Jos. Should I go again with the question? I'll read the question again. Bearing in mind that the jurisdiction of an arbitral tribunal is ordinarily civil and is particularly circumscribed by law and the agreement of the parties, how can the issue of corruption, which is criminal in nature, be validly raised before an arbitral tribunal?
Okay, so I mean, remember, when you're raising corruption, you're not trying to make a finding, to criminalize the party. You're using it as a basis for nullifying a contract. So it's basically, is this contract null and void and against public policy because of the allegation of corruption? I think that is the answer in a nutshell. So a tribunal does have jurisdiction because it relates to the contract and whether it remains enforceable.
Okay. Just a minute. There's a bit of scrolling, but I'm watchful of time. We have probably another 2 minutes on this, and we probably would have to look for the speakers on LinkedIn. I think we have one more question and then we go. Just a minute. Okay, I don't see any more questions. If there are questions, they probably, went all the way up. Okay, so what are the legal effects of the multinational company that always come with their agreement format based on international laws, in which African countries, where most of the mineral resources are deposited, but are undermined by the developed countries? That's a question that affects what was just discussed, but I'll read it again. What are the legal effects, or what is the legal effect of multinational companies that always come with their agreement formats based on international laws, in which African countries are mostly, with natural resources, are mostly undermined by developed countries? He's saying, so come with a contract format that favors more the investor and doesn't favor the state. I think that's where the question is tilting towards, if I understand clearly. It's by Umar Al-Haji. I don't know if any of the, maybe Dr. Nalube.
Yeah, I can address that. Those are mostly, sometimes they're called model agreements. So an investor would come with a model agreement or a model mining agreement, and they believe that the terms of that agreement would be beneficial for them, also beneficial for the host states. The first thing to do is, because remember, we have to start by acknowledging the fact that the country has sovereignty over its natural resources. So before you accept that model agreement, have a discussion with the investor, negotiate terms that will also be beneficial for you as a host state, but also beneficial for the citizens. Because there is no law that says that, oh, you have to agree with the model agreement that the investor has come with. Remember, they're also testing the waters. They're testing the waters to see if you are strong enough to negotiate with them, if you are strong enough to object to some of the terms that they're offering, or if you are timid and you believe that whatever they're putting on the table is the best thing because they're coming from developed countries. So my answer would be, if there is a model agreement that the investor has brought, it's the duty of the host state to sit down and look at the terms of the terms and provisions of that model agreement and align them, change them to align with the unique needs of the country. Because model agreements or agreements that will be effective in a developed country are not going to be effective in developing countries. There are certain things that we need in developing countries, like developmental infrastructure, that might not be a priority in developed countries that have already had their infrastructure developed for centuries. So we need to look at the unique needs of our countries, and then the government has to sit down and negotiate that model agreement based on their unique requirements in a country. So they shouldn't be bullied that if an investor has come with a model agreement, you are under an obligation to accept those terms or to accept the provisions in that agreement and how they have been structured.
Thank you. I'll take this question and then we'll move on with closing remarks.
Yeah.
Okay.
And
Yes.
I think I would like to agree with Doc and obviously just to give, you know, a personal experience with negotiating contracts with the government. I mean, we did have, I think, conversation that was intended to be part of this webinar in terms of expertise. I think it's really important that we gain the relevant expertise with regards to defensive drafting nowadays, you know, specific industry related solutions that can be included in contracts. I mean, sometimes it's really sad when you sit and you have your own government on the other side and you can see them being bulldozed by the investor. You know, it's terrible. So I think it's important that we gain the relevant expertise to actually assist our governments come up with proper agreements that will actually be beneficial for years to come.
Thank you so much. We have more questions, and I'm thankfully the CIF is reposting some of the questions. So yes, just a minute. There's there is advocacy for arbitration process involving state investor to waive confidentiality to avoid allegations of corruption. How do you react to this advocacy? I'll read again. There's advocacy for arbitration process involving state investor to waive confidentiality to avoid allegations of corruption. How do you react to this advocacy?
Yes, I believe I think I did mention that is from a corruption point of view. I think greater transparency is the way to go, especially when it comes to corruption. I mean, sometimes you actually have requirement, regardless of the duty of confidentiality in arbitration. You have state laws that actually provide for the duty of disclosure. So I believe that advocating for this transparency is the way to go.
Do you have any reactions to that, Dr. Nalwe?
No, I totally agree. We need to advocate for transparency.
We have say 5 more minutes. So if I missed your questions, I would appreciate it if you just repost, because I'm also getting messages that I'm missing some questions, but I just can't find those questions. So please, if I missed your questions, because there are other messages that come in that are not questions, they're just simply people's Supreme Court numbers. I would appreciate if you can repost your questions so that we can take them. Please, if your messages now are simply just Supreme Court numbers, I would appreciate if we pause on that so that we can get just questions. And then afterwards, you can continue posting that. Thank you. Good. Is it possible for, okay, how possible is arbitration for reparation in ongoing ecological and economic damage? How effective, I think is effective, how effective is arbitration for reparation in ongoing and ecological and commercial damage? Should I take that question again? How effective is arbitration for reparation in ongoing ecological and economic damage? That's from, okay, yes.
Okay. Yes. I mean, arbitration is actually the way to go. It boils down to the expertise. You won't find that relevant expertise other than in an arbitration, because it allows you to get people that are actually qualified to provide, you know, whether it's the quantitative, how are you calculating the damages? And it matters like ESG, you know, the actual loss and damage is very difficult to quantify. So it requires a certain level of expertise. And you find that arbitration is the form of dispute resolution that allows for this level of engagement with third-party experts.
Thank you. The next question from Emmanuel Ibekwe. The question is, what would be the attitude of the arbitral bodies or of an arbitral body to the arbitrability of contracts tainted with fraud? What would be the attitude of the arbitral bodies to the arbitrability of contracts tainted with fraud? Yes.
So I did give the distinction in terms of how it would affect the particular contract. So maybe this question came before that. But ideally, you've got two schools of thought or two possible outcomes. We did indicate that if you're talking about ISDS, investor state, or treaty-based dispute resolution, essentially we're saying the investment itself is not protected, so the underlying arbitration agreement does not exist. So we're dealing with an issue of jurisdiction of the arbitral tribunal from the get-go. With commercial arbitration, we're then saying that, if indeed there is allegations of corruption, the arbitration, but that corruption must be proved to then determine whether or not it affects the validity of that contract.
Thank you. I think I've seen this question over and over again. I'm sorry I missed it earlier. From Gabriel Ode. The question is it possible to factor artisanal miners into mining agreements in order to legitimize their operations since they have become major players in the mining sector?
I can address that.
Yes.
So for artisanal miners, the starting point would be, are their operations formal and are they legal? Because some countries have legalized and formalized artisanal and small-scale mining, and others have not. And artisanal miners play a very big role in our mining sector, especially in Africa, but they also have to be more organized. Before you even think about a mining agreement to factor in artisanal miners, the question is, have they even registered themselves or as artisanal miners? Because that's also another unique sector that we have to look at. So the starting point would be to legalize it, formalize it, register all artisanal miners, and then let the government have like some sort of agreements on how these miners are supposed to be operating. But what we're seeing right now in different countries, including Ghana, is that it has been a bit hard to govern and manage these artisanal miners because of the clashes of interest between the miners themselves and the government. And in some cases, the artisanal miners clash with large-scale miners. So we need to first sort out all these issues that are making it hard for the formalization to be effective. And once we have sorted that out, then we can talk about mining agreements. But right now, as it stands, unless if we have like stronger cooperatives, because now most artisanal miners are forming cooperatives that are making it easy to discuss and negotiate with the government. So once we achieve that in different countries and we can be able to manage them in a way that is more recognizable, then we can talk about mining agreements. Other than that, how are you going to sign mining agreements with people who are going to operate for 3 months and then the next 3 months they're not going to be there? So artisanal mining has those unique aspects that need to be addressed first.
Thank you. So I have a question, but it seems like a long read, but I will go ahead. Oh, I'm even seeing PTO. That's please turn over. It seems like it's really long, but I would read if it's a question that can be understood by the panelists. I'd like to briefly. This is from. This is from Dr. Ademola Bambushe. So I'm just going to read it anyway. So Dr. Ademola says, I'd like to briefly engage with Dr. Nanule's points on the utility of stabilization clauses. While I acknowledge Dr. Nanule's view that the political environment is more stable now compared to previous years, I also agree with Daniel's observation that in many emerging markets, changes in governments often lead to policy reversals, especially those linked to prior administration. Dr. Nanule referenced the role of bilateral investment treaties, but these are only applicable where a treaty exists between the host state and the investor's home state. This raises the question, what protections are available to an investor when no BIT exists? That is one. So our first question is, what protections are available to an investor when no BIT exists? Then moving forward. Furthermore, while there may be domestic laws offering more degree of stability, enforcing these rights often requires recourse to local courts. As we all know, one of the key motivations for choosing arbitration is the perception of neutrality. As a Nigerian, I appreciate the good quality of our judiciary, but how can we expect a foreign investor to be confident that local courts will not favor the government in a dispute? Finally, when it comes to enforcement, an investor would typically prefer the protections offered by the New York Convention, protections that may not be guaranteed under local law. So playing the devil's advocate, doesn't a stabilization clause offer a form of contractual certainty and assurance for investors that neither domestic legislation nor the absence of a BIT can fully provide? Yes, this was long, but yes, 2 questions. I can read the first one and then go straight to the second one because we kind of get the context of it. The first one is, this raises the question, what protections are available to an investor when no BIT exists? And the second question is, so playing the devil's advocate, doesn't a stabilization clause offer a form of contractual certainty and assurance for investors that neither domestic legislation nor the absence of a BIT can fully provide? Thank you, Doctor.
Okay, thank you. Let me respond to that. And let me first actually start by asking the question, which I'll also answer myself anyway. When he says that when new governments come into place, they are sometimes forced or attempted to change the regulatory framework. That is true. But the question is, why would the new government or administration be forced to change the regulatory terms or the legal terms? And to answer that briefly, it's very easy. It's because those terms were not favorable for the host state, because no sane government is going to come in and they look at the terms of the agreements that were initially negotiated and that the terms of the agreement are benefiting both the investors and the host state. And then they'll be like, oh no, you're giving us a lot of revenue. We don't want it. Let's negotiate. We want less revenue. No sane government is going to come in and do that. In most cases, governments have been forced to change the regulatory framework or even the legal framework, or even to nationalize because of the unfavorable agreements and mining contracts that were signed by the previous regimes. So the starting point for the investor is to have some conscience, know that obviously they're not charity organizations, that they are there to make charity. They're in for profits, but know that there are always consequences to your actions. If you're going to take advantage of these developing countries and you negotiate terms that are only benefiting you, the new government will come in with better experts who are going to look at those terms and they'll have to renegotiate them for public interest. So that is the starting point. Negotiate fair agreements if you don't want the terms of the agreements to change. Then the second question is, which other mechanisms are there if the stabilization clauses are not provided for? Well, like we mentioned, there are investment laws, there are constitutions, and the presence of a stabilization clause doesn't mean that the state will not make any changes to the laws. In Libya has stabilization clauses, but the 1990 cases, petroleum cases that evolved in Libya were about nationalization. And why exactly were they nationalizing? Because the country felt they're not benefiting from the oil industry. So whether the stabilization clause is there or not, it doesn't stop the country or the state to exercise its right to change laws. But however, there are consequences to that. And what are the consequences? The state will bring a dispute before international arbitration. And that also takes me to the fact that most mining agreements have arbitration clauses. With the arbitration clause, the impact is wherever a dispute arises between the host state and the investor, it has to be resolved through international arbitration. So you're not going to be forced to rely on national courts that we all often say that they are not reliable. And the arbitration clause will have the seat of arbitration. It will also have the applicable laws. And those arbitration clauses are common clauses in all mining agreements, whether in developing countries or the developed world. So the presence of a stabilization clause doesn't mean that the state will not make any changes. It will, but rather the presence of an arbitration clause will be able to protect the investor to the effect that whatever changes that they make, whether it's relating to stabilization clauses or even whether it's relating to other provisions in the contract, they have an avenue of resolving that dispute through international arbitration. So I stand with my submission. You don't need stabilization clauses to protect investors because there are other investments in our countries. You mean that all those investments, they offer stabilization clauses? Why do you pick the extractive industry that is going to last for 20 years and you feel you have a right or it's right for you to offer that freezing clause that will limit the ability of a country to increase taxes or royalties or even to introduce laws that are going to benefit the public because we are scared that investors will not come. So yeah, you don't need them.
Okay. Thank you very much. I believe this should be a subject for a debate one of these days, because quite frankly, knowing Dr. Bamboshe very well, if you give him a panel, this would continue without end. I equally have my views on this point, and I'm going to just say we'd leave this and would have to end here. I'm sure there are so many questions that would have been missed. Please do well to maybe send your questions to any of the speakers. They're on LinkedIn. If you send it to them, they would actually address them. Or you can send it to me if you know me, or if you can send, or if you find me on LinkedIn, and I will send it to them to answer it for you. All right. Thank you all very much for joining today's webinar. My name is Daniel. I didn't introduce myself at the beginning. Thank you so much, Neka Ophelia. I thought you would have a question. My name is Daniel Ihweze. I'm a senior associate at Plodic Bozimo & Company. I'm a dispute lawyer. I do litigation. I practice litigation, commercial arbitration, international commercial arbitration, investment arbitration. I'm an active member of the CIAB. There's so many things I would like to say, but I would leave my introductions there so that I don't take any more time. I would then move over to the next session, which will be by the CIAB chair, Nigeria, for her to give her closing remarks.
Thank you very much, Daniel. On behalf of the CIAB, Mr. Ribamire, I would like to appreciate yourself and Nakasamba and Victoria for a fantastic and very engaging session. It's been amazing how an hour and a half has just gone, and we're barely just scratching the surface. So we hope to have you again next year. And we hope that this panel will definitely be ready for a debate. But you've opened up so many questions and areas for us as practitioners to think about. So thank you so much for your contributions and your submissions. Thank all those who have attended and all the comments in the chats. On behalf of the CIAB, I want to thank all those who have attended our specialist webinars this year. We had about 6 or 7 of them. We'll go on break now and start in January, most likely with sessions on either use of mediation in arbitration or construction arbitration. Whatever it is, we'll be in touch with you. Please have a very wonderful weekend, and we hope to see you at the conference next month, November. I hope you have registered. We have a few days more to register if you haven't registered. To see you at the CIAB conference, and to all colleagues and to all members have a lovely weekend and a great day. Thank you once again, panelists. Cheers.
Thank you. Have a good day.
Thank you. Bye.
Thank you. Have a good day. Bye, everyone.